Welcome to INN's Advocate. INN's Advocate is a platform for lawyers having less than 5 years of practice. Today we have with us Advocate Yash Arora. Advocate Yash has graduated his law from Father Agnello Law College, Vashi in the year 2021. Advocate Yash practices both in civil and criminal areas, predominantly in the appellate courts. His practice areas are Thane and Mumbai. Today he is going to speak on Synopsis of the Anti-Corruption Law. So without wasting further time, I would request Advocate Yash to commence with his lecture. Thank you.
Greetings, one and all. The topic for the present day discussion is Prevention of Corruption Act. Now, the Prevention of Corruption Act was broadly enacted in the year 1947. Now, before getting into the nuances and the importance of the enactment of the said act, let's just understand the history and background what necessitated the enactment of this act. Now, the Prevention of Corruption Act was enacted in the year 1947. Even prior to 1947, corruption was a huge menace in the country. Prior to enactment of Prevention of Corruption Act, the offense of corruption was only bound to be imprisoned in under sections 161 to 165A of the Penal Code. But since that was not enough to control the menace of the corruption, the said act had to be enacted. After the enactment of the Prevention of Corruption Act, sections 161 to 165A of the Penal Code were repealed. Now, getting into the British era, right from there, the menace of the corruption was extremely rampant. When we look at the British era, starting from Robert Clive, he had looted India to the tune of 7.4 million pounds in the year 1750s. Subsequently, in the year 1760, another person named Lord Cornwallis had looted India by taking bribe of 1 lakh rupees back in the year 1760. Subsequently, in the year 1860, East India Company was formed. Now, this company was a shell company established by the Britishers only to camouflage the act of corruption. Now, it is only when the corruption was starting entering into the education sector, the ordinance, the criminal ordinance of 1944 was passed, which says that the corruption activity should be stopped and there is a need of enactment of a special law called Prevention of Corruption Act. This act was first enacted in the year 1947 as per the Criminal Law Ordinance of 1944. Subsequently, the act had gone two major amendments, one in the year 1988 and another in the year 2018, which is the present Corruption Act which we are dealing. Now, a very undecorated, a very simple information about what the act does is, this act broadly imprisons and punishes two kind of offenses. One is bribe, taking bribe, every offense relating to bribe, and the other is possession of assets which are disproportionate to the known source of income of the accused. Now, in the said act, both the public servants and a private individual can be arraigned as an accused. Now, why so? We'll be understanding in few important definitions of the said act. Few of those definitions are public duty, public servant, and undue advantage taken by said people. Now, public duty and public servant are defined as per section 2B and 2C respectively. The ingredients of the sections are, the term public servant and public duty has been enlarged and their scope have been enlarged from section 21 of IPC to bring all the offenders under the ambit of public servants, so that no person could evade the clutches saying that he is not a public servant and therefore this act cannot be levied upon him. Now, as per the enactment and the amendment done in the year 1988 to include various people within the framework of the public servant now is to include central government employees, UGC employees, nationalized banking employees, chancellors, academicians, judges, and even arbitrators to that effect. Now, this has increased. The said web has now widened in 1988 amendment. Section 2B says duty in charge. The public duty who is in charge in which the state, the public or community at large has an interest can be said as a public servant who is doing his duty. Now, a public servant need not necessarily be employed as a public servant. He can also be constrained as a public servant if he is receiving any kind of gratification, commission, or any subsidy, even from the government. Any person performing public duty is a public servant. He should not necessarily be a public servant. Now, here the question is that whether the PM and CM are still construed as public servants. So, the Supreme Court in the case of M. Karunanidhi versus the Union of India in the year 1979 had stated that the ministers appointed are under the authority of the governor and receives their compensation for the labor provided by them in the service of the people, and their salaries are being paid by the public money, and therefore even CMs and PM is also a public servant. Now, coming to another celebrated case of a global bank trust case, Supreme Court in this matter has very widely broadened the definition of public servant. In this case, a Oriental Bank of Commerce had taken over a private sector bank. Now, when the Oriental Bank of Commerce had taken over this bank, the auditing team of Oriental Bank of Commerce have scrutinized and have known that the directors and other higher officials of the said bank have granted loan to people knowing that they are not at a position to repay that loan. Meaning they have played with the public money who have deposited in their bank just to take illegal gratification. The said prosecution was done on the committee members of the private sector bank who had enlarged loan back when they were in the authority. Now, the new bank who has taken over, which is the Oriental Bank of Commerce, had prosecuted them. There was charge sheet to that effect that so and so person have been playing with the public money and they need to be prosecuted for an offense of disproportionate asset in the said act. The trial court, while discharging the said accused, have stated that they are not having a position of public servant because they are not doing any duty as per public at large. Subsequently, the High Court had also taken the same view. The prosecution now goes to the Supreme Court. The Supreme Court very well widens the web, saying that even a person who is entrusted in a bank and who has capacity to play with the public money is a public servant. And subsequently, the cognizance was taken even against the directors and other members of a private sector bank to play and to misappropriate the monies of the public who had deposited in their bank. Now, subsequently, in the case of Ramesh Gilli, in the year 2015, Supreme Court categorically held that a private individual cannot escape the clutches of law only because he is not under the framework of a public servant or who is not directly empaneled or is working in any other government office. Now, there are instances and cases where a private tuition class teachers were held under disproportionate assets, saying that they are not giving admissions to other students. There, it was held that a private tutor who is working at a coaching class or who is owning that coaching class cannot be considered as a public servant. And only the teachers who are involved in government colleges and private colleges are considered to be public servants. Now, in another instance, where a magistrate had appointed a court receiver to perform some duty, and it was found that the court receiver had taken a bribe money to give a favorable report, and subsequently he was prosecuted for it. Later in stage, it was found that the magistrate was not in power to appoint that particular court officer to perform that job. Hence, the appointment of a person is equally important. In the said case, the court receiver was released because his appointment was not appropriate. So, appointment of a person and his duty as a public servant both plays an equal role to arraign that accused and convict him as a public servant. Now, getting into the another definition of undue advantage. Undue advantage is defined under section 2D, basically saying any gratification whatever other than legal remuneration. Now, multiple times, if people are accepting undue advantage, which means that they are accepting bribe, it leads to an offense of disproportionate assets, because at the end they are just accumulating those assets which are disproportionate to their known source of income. Now, gratification can also include giving employment to another public servant's son or daughter. Now, majorly as per Act, Section 7 to Section 16 defines three major categories of offences. One, relating to bribe; two, relating to disproportionate assets; and three, abetting a person to accept that bribe. Now, under the Anti-Corruption Act, the act of taking bribe, giving bribe, and demanding bribe, and abetting a person to collect that bribe, all constitutes an offence. Section 7 makes it a crime for a public officer to accept a reward other than a lawful pay in exchange of performing an official act, making it clear that under 1988 Act can be said that any receipt of any illegal gratification or any valuable item for any exchange for discharging public duty amounts to an offence under Section 7 of Prevention of Corruption Act. The two main ingredients that prosecution needs to prove to arraign a person as an accused under this act is to prove demand and acceptance. Now, if there is only demand, which means there is an attempt to create a acceptance of bribe, only acceptance makes no offense. Demand, when combined with acceptance, creates an offense of bribery. Now, this is important because the accused, when found guilty, will always say, to use one of their yardstick, is that whether have I demanded money or is it a gift. For example, if the accused person is sitting in his office and he does not make a demand, and if a person directly hands over him a sum of 10,000 rupees, that does not amount to bribe, because there the prosecution fails to establish that a demand was made by the public officer. So, subsequently, the Supreme Court in the year 2020, by clarifying the demand and acceptance in the case of N. Vijay Kumar versus State of Tamil Nadu, has held that recovery by itself cannot prove charge of prosecution by accused. Similarly, in the case of CM Girish Babu versus CBI, again by the Supreme Court, it is held that to prove Section 7 to 13 and charges under this section, it should be proved beyond reasonable doubt that the accused voluntarily has accepted money, knowing it to be a bribe. Absence of proof of demand of illegal gratification and possession of that gratification is not sufficient to constitute it as bribe. It can then be considered as disproportionate assets, which is altogether a different part of the act. Now, there can be a presumption under section 20 of the Act, which says that a person who is possessing assets which is disproportionate to his income can be presumed that he used to accept a ton of bribe during his course of employment as a public servant. Now, let's now assume a case of trap. Now, what is a case of trap? Where a public servant who makes a demand and there is an acceptance of that demand to discharge his official duty. That is bribe as per, that is the offense of bribe punishable under section 7 of the said act. Now, the investigating officer has to lay down a proper trap in order to collect evidences as to how that person will be convicted. Now, what happens is that, for example, a person to whom a demand has been made, he will then approach to the Anti-Corruption Bureau, making a private complaint, making a handwritten complaint or an oral complaint, saying that so and so person is demanding X amount of money to perform an official duty as to which my my things are getting hampered, my business is getting hampered. Now, what happens is the Anti-Corruption Bureau lodges an FIR. Or in a different scenario, we can assume that the FIR is not being registered. Then that complainant can approach a special court, which is a sessions judge, special court assigned to the to deal with this particular act. That court will be treated as a magistrate court under this act, and that court will decide an application under 156(3) whether an FIR is made out for the offences alleged against that particular servant, public servant. Now, assuming that the Anti-Corruption Bureau has lodged an FIR either by himself or by the direction of the special court, he will then pass on that FIR to the said court, and the Anti-Corruption Bureau will issue a letter for to a department which is higher in rank to the alleged offender to have two trap witnesses. Now, the Anti-Corruption Bureau, after going through that FIR, collects two trap witnesses. These trap witnesses and the complainant are then called into the office of the investigating officer. The investigating officer then explains it to them that there has to be demand, and only after that demand the money should be handed over to the officer, to the alleged accused person. Now, what happens? There is a test of phenolphthalein. Now, the complainant is always asked to bring his own money. The department money is not used. The complainant gets his money. The trap witnesses are there. Now, the investigating officer prepares a solution. He mixes 250 ml of water with 250 grams of sodium carbonate solution. A solution is formed now. The investigating officer asks the complainant to dip his hand into that solution. When a complainant with his bare hands dips into that solution, no color change happens. Subsequently, a phenolphthalein powder is applied on the notes which were to be handed over to the alleged accused person who has made that demand. Now, the test has been done before all the witnesses that in a phenolphthalein powder, when applied to notes and then dip into that solution of sodium carbonate, will turn pink. Every punch is recorded, their statements are recorded, that everything has been explained to them. Then there is a case where the investigating officer, along with the other subordinate officers, applies speaker microphones inside the shirt of the witnesses, including the complainant. A memory card is chipped, everything is set. They then approach to the particular accused person's department. Now, the complainant is very rightfully explained that unless and until demand is not made, you should not hand over the money. Because if money is handed over without the demand made by the accused person, there is no offense of bribery. Now the accused enters into the cabin. The demand is made by the officer. Everything gets recorded in the microphone, which is tipped inside the clothes of the complainant. Now, since as soon as the complainant hands over money to the accused person, a signal has been given to the other two panchas. The two panchas come inside, the investigating officer comes inside, the accused person is now fully restricted, surrounded by all the panchas, including the officers. As soon as the money is touched by that accused person, the investigating officer asks him to dip his hand into that solution of sodium carbonate. The phylloxanine powder, which was applied to the notes, has now been transferred to the fingertips of accused person, or wherever that note has been kept by the accused person, either in the pockets of his clothes or his cupboard drawer, wherever it is. Every piece of cloth is then dipped into the phenolphthalein powder. Every location is then poured, either the solution is poured to change that color, or it is dipped. Now, every panchas record their statement that so and so were the notes, which were dipped, hands which was dipped in the phenolphthalein powder, and it turned pink, which means the demand is recorded, the acceptance is now proved by the phenolphthalein test, and this is how a trap is laid down in order to convict a person under the offense of bribery. Now, generally what happens that in the case of trap, the investigation is now over. The investigation is absolutely over because there is an inquiry has taken place before the trap is laid down. The entire investigation revolves around the trap. So there is no need of the accused person to be behind the bars as per the criminal law. But sadly, seldom it is followed. Nowadays, we find that even in the case of trap, people usually spend over a week behind the bars just to say that a huge money is involved. But in fact, the bribe has been taken, everything is recorded, investigation is absolutely over. Now, the said procedure is mentioned in the Directorate of Vigilance of Anti-Corruption Manual. This procedure is not mandatory, it is just a directory procedure. But also it keeps in mind that any lapse or weakling by the prosecution will result in acquittal of the accused. The same process shall also lie to a private person who says that he will accept that money in order to influence a public servant to do a job by taking money. If there is a private individual who is abetting bribe, the same trap can be levied upon that person as well, and he will certainly be convicted under Section 7, precisely to be precise, under Section 8 of the said Act. Now, this is broadly what bribe means, how bribery offences are investigated. Now, coming to the second chapter of the Act, which is possessing assets which are not in proportion of the income of the accused persons. Now, possessing assets is not an offense. It is not an offense to have a very luxury car, to have a huge mansions, etc. Possessing assets which you cannot satisfactorily account for is an offense. But disproportionate assets in itself was never a specific offense. Even when it is not uncommon that a public servant were found to be in possession of disproportionate assets, and though it was not a substantive offense under the Penal Code or even under the Prevention of Corruption Act until 1947, there is a case law about disproportionate assets which had convicted a person even before it has become an offense under Prevention of Corruption Act. Now, in the earlier Prevention of Corruption Act, the offense of habitual bribe taking, habitual acceptance of gift, habitual acceptance of gratification were used. Now, if a person demands money, he can be a trap can be laid down, he can be convicted for acceptance of bribe amount. Now, how do we actually make a person accused who is habitually taking bribe and there is no complaint raised against that person? He is collecting money, he is building up assets. There is no way that a person can be accused of that bribe. Therefore, it is an offense for possession of disproportionate assets, which became an offense even before it was formally entered in the statute, making it an exception to criminal law. This was used to punish the accused, though not for possession of assets, but to take habitual bribe, habitual gratification, and habitual gifts by using standard of known source of income and total assets. In the case of disproportionate assets, nothing major comes during inquiry. It is only after investigation that it is known that a public servant owns assets which are disproportionate to his known source of income. Now, what is known source of income? A known source of income can be legitimate or illegitimate. Certainly, an accused person has to deliver his and show what are his legitimate source of income or a lawful source of income that is to be considered as known source of income. A public servant needs to prove his lawful source of income which he had already declared with the government. For example, now, generally in these cases, the accused person take a stand that I have been acquiring so and so assets not through my money, but through the money acquired by the businesses conducted by my wife and my children. And when investigated, it is always found that these businesses were started only after he has commenced the duty of public servant. So this defense can no longer be considered because it is always presumed that the monies collected while performing his public duty was then transferred to his wife's account or children's account from which they are running businesses. So this defense is ruled out. Coming now to combat such diversions and conversions of black money to white money by public servant, the conduct rules of Central Civil Services had undergone certain amendments to specify what is known source of income. Now, known source of income by its new definition means that income which the public servant has disclosed to the person of authority, he is required to disclose as per the rules. He have not disclosed, it is not known as known source of income and cannot be used as a defense later. Now, for example, if a public servant is acquiring a immovable property, he needs to inform his superior that he is acquiring an immovable property. Subsequently, if a public servant, even while acquiring a movable property, which is above a threshold limit, has to then inform his superiors within the 30 period that he has acquired this movable property. Then a public servant should also file an annual report saying that what were the properties that he has acquired during the course of that year when he is employed and the properties that he has acquired before he was employed as a public servant. Public servant should also disclose the properties which are given to him as a matter of inheritance. He should also disclose that when his son and daughter is entering into public service. No public servant should ever accept gift from his superior or any other public officer. No public servant is also allowed to engage himself in any trade or active employment while being in an organization of a public service. Now, public servant, even after receiving a gift, should disclose that who has given him the gift, why was the gift received to him. Any assets which is not disclosed by the public servant cannot be used as a defense later when that particular public servant is prosecuted by saying that he has failed to disclose these assets. Subsequently, the Supreme Court in the year 2001 in the case of N. Narasimha Rao versus the state of Andhra Pradesh has held that it will be presumed that an expensive item or a pleasure discovered in the hands of a person will be presumed that a man is a corrupt. Meaning, if a man is earning 100 rupees and wearing a watch of 1000 rupees, as per this particular judgment of the Supreme Court, it is assumed that the man has acquired illegal gratification habitually to own such assets, particularly when he is not disclosing the source of that assets. The accused then needs to revert. Now, if at all prosecuted, the accused will have to revert to the court saying that these are his known source of income, these are his probable income, probable liabilities, and probable savings, by way of which he is acquiring these assets. Now, that is what it happens for him to refute the presumption of accepting bribe. Accordingly, a guidelines of presumption was laid down by the Supreme Court in the said Act. Now the other major offense is Section 8, which deals with the agents. Now, agent is basically a person who says that I will be accepting money and I will be influencing a public officer on behalf of a person whose business is stopped. Now, this is an instance where money is given to the public officer or not. If any person says that he is taking money to influence a public officer, that person is held to be an accused under Section 8. No person can accept any kind of money by saying that he is going to influence a public officer to make a favorable order or to make a favorable way to partially and to create any kind of partiality against a particular person. Now let's get into some certain technicalities of how the Act proceeds. As per Section 4, the offence of the Prevention of Corruption Act should particularly be dealt with a special judge. The said trial should be concluded within a period of 2 years. If not concluded, a specific reason should be mentioned and an extension can be taken up for 6 months. And these 6 months can be repeated only until the completion of 4 years, till the extension of 4 years is granted. Now, a very important factor is that before prosecuting any accused person under the Prevention of Corruption Act, it is extremely important that a sanction is granted. Now, what is sanction under the Act? The sanction, as per Section 19 of the Prevention of Corruption Act and as per 197 of the Code of Criminal Procedure, any investigating officer who seeks sanction, he should seek sanction from the investigating officer, should seek sanction from a superior officer of the accused public servant by presenting all the details of the investigation before him. And once the sanction is received, the court will take cognizance and the accused may be prosecuted. Now, during the sanction, the accused should be given an opportunity to be heard. Now, this is the thing which is amended in the year 2018, which makes it an exception to criminal law. Because for any other criminality or for any other prosecution, accused is never given an opportunity to be heard unless and until cognizance has been taken by the court. It is only under this act that while providing sanction, the accused is given an opportunity to be heard so that an honest public servant should not be dragged into this menace of the entire trial. Anyway, the sanction should be provided within the period of 3 months when demanded. If sanction is not allowed, it can be challenged before the appropriate court. In a nutshell, where a FIR is registered against a public servant who requires prosecution, sanction depends upon the nature of allegation. Sanction is only required for the acts performed in the discharge of official duties. Sanction is not required for the acts outside the scope of official duties. Now, it is advisable to carefully analyze the specifics of the FIR to determine if the allegation falls in the ambit of the official duties. If the FIR involves sanctions that are clearly outside the scope of official duties, it may be prudent to proceed without seeking prosecution. Now, for example, a public servant accepts bribe to do a particular act which falls under his duty. That to prosecute him under that act, sanction is necessary because that falls under the domain of his official duty. Now, if the public servant is acting as an agent, saying that you give me money, I'll pass on it to some other public servant, that does not fall under his official duty. So, in order to prosecute a public servant under Section 8, sanction might not be required, but to prosecute him under Section 7, sanction is certainly required. Now, there are other judgments of the Supreme Court. One last judgment to court of Neeraj Datta versus State of Delhi, which says that in the course of a trial of Prevention of Corruption Act, where the complainant is manipulated, now the complainant goes hostile, the complainant dies, the accused can still be prosecuted and convicted on the basis of the investigation by applying the law of circumstantial evidence. So it need not be necessarily be a case where the complainant and all the other punch witness should not be hostile. If anyone goes hostile, the accused person should be prosecuted and subsequently convicted on the basis of circumstantial evidence. So this in a nutshell covers my topic of Prevention of Corruption Act, where we have discussed certain definitions, and the twofold offenses described under the said act, which is bribery and possessing assets of which are disproportionate to their source of income. That's it. Thank you, viewers.
Yes, thank you very much.
Great
It was
process.
really an exhaustive synopsis because you had covered the sections. In fact, you had covered the manner in which the traps are laid.
Yes,
Because
yes.
the technicalities which you spoke, कि वो notes को क्या क्या solution लगता है, I
Yes,
think that is not known to everybody. So probably by this kind of an your lecture, people will know the technicalities which are involved in the process of doing the trap. So it was
Certainly.
very nice to hear you. Thank you very much.
Great.
And a small token from Hammurabi to you.